a situation where you already have your green card, where you already have your 2-year green card, and now you have to go to the 10-year green card. But in cases like that, you may still be in a situation where you're being mistreated, and you have to then apply you'd have to apply for the 10-year without that spouse to go from the 2-year green card to the 10-year green card. So I'm going to explain this to you. In the meantime, you can put your questions in the comments, and I will answer as soon as I'm finished just discussing this topic, which should just take a few minutes. Now, removing the conditions on your green card, what does that mean exactly? So if at the time, if you already have a green card, it's time to check your green card to make sure you have to see if you have the 2-year or the 10-year, if you don't know already. That's because when you apply for the green card, if you apply through a spouse, a US citizen or legal permanent resident spouse, if you, at the time of the approval of your green card, you've been married for less than 2 years, then you're going to get the 2-year green card. So this is a temporary, called a conditional green card, 2-year conditional green card. And what it does is it allows a 2-year period, sort of like a probationary period, for you to continue your bona fide marriage. And when it's around 90 days before it expires, you're going to have to then apply for the 10-year again. You have to apply for the 10-year with your spouse unless you qualify for a waiver. And you do have to formally request this waiver so that the USCIS can allow you to apply on your own without jointly filing with a spouse. And this is where VAWA is going to be very, very important, because VAWA not only applies to individuals who don't yet have their green card, it also applies to individuals who have their 2-year green card. So if you're in a situation where you're being mistreated, you're being subjected to extreme cruelty by a US citizen or legal permanent resident spouse, and you currently have the 2-year, you know that you're now going to have to apply for the 10-year, but you don't trust them to apply with them, or you are in a situation where you're now separated because you had to remove yourself from the abuse or mistreatment, then this is for you. Now, if you're jointly filing with your spouse, you must file 90 days before your 2-year green card expires. However, if you are if you're divorced before the 90-day period comes, or you're separated, or you're even living with a spouse, but you don't trust them to apply with them because they're mistreating you, you can apply at any time. If you can apply at any time before the 90-day, before your card expires. So that means that you're able to submit that petition and the waiver application to apply on your own without that spouse at any time. Say you've already applied for jointly with your spouse, but now things have changed, or now you really would like to get out of the situation. You really want to apply on your own. You don't trust your spouse to apply for them. You can still submit this waiver even after you've submitted the application jointly with your spouse. That will change it to an individual application, and it becomes confidential. If you apply before the both of you even jointly file, it is completely confidential. They will not let your spouse get involved in your process. And whether you're living with them or you're separated with them, you can still move forward with the process of getting your 10-year green card. Now, once you apply, you're going to receive an extension that states that this is applicable after the 2-year period after the expiration date on your green card. Once you're able to get this extension, it allows you to continue to be a permanent resident. So many people have the misconception that If you have a 2-year green card, you don't have the same rights as a regular 10-year green card holder. That is not true. You're still able to apply, travel, you're still able to carry on, work, do everything just like a permanent resident would. Especially after you get that extension letter, you will continue. That is proof. You can travel with it. You have to travel with the extension letter and the expired card to show that you continue to be a permanent resident. And when the 2-year card expires, the 2-year extension letter expires, you should continue to set appointments at the office to get what's called an I551 stamp in your passport. So as long as your case is processing, you will always be able to show that you're a permanent resident. So what does mistreatment look like when you're applying for this waiver? Well, it's going to look like any other situation under VAWA. If you're being mistreated verbally, mentally, physically, but physical violence or threats is not required. If you're being abused emotionally, if you're being subjected to extreme cruelty. So if they are telling you that they're still holding this 2-year green card over your head. They're trying to get money out of you, financially abusing you, if they're alienating you, if they're jealous of you, if they are, trying to keep your family members away from you. These are examples of behaviors that if you're subject to it, will qualify you to apply for the waiver where you can apply for your own 10-year green card coming from a 2-year green card. So this is also, VAWA does not just apply to individuals without the green card, it also applies to individuals who have the 2-year green card. However, in that case, you apply via the waiver. It's the form that you use to remove the conditions on your 2-year green card to get the 10-year. Is the I-751. And so it's called the I-751 waiver. And it's very important. At any point, you know that you're not going to be able to apply jointly with your spouse, or you don't want to apply jointly with your spouse. It's time to go ahead, get that legal advice, get the representation, and formally submit that waiver at any point in the process. So it could be any time after if you've already jointly applied and you now need to apply on your own, you can do that. If it's way before, if at the point this is not going to work jointly with your spouse, you can file this waiver. So it's a very, very important form of relief that I'm this entire week, I'm sticking with the theme of VAWA and how it can assist you through your immigration process. And yes, that includes if you already have the 2-year and you're going to the 10-year. So now that I have stated my piece, I'm going to move on to questions. But I want to let you know that I am available to represent you and to assist you. First, we evaluate your case in detail to make sure that we've covered all your situation, that we've properly advised you of your options. And then should you opt, we move forward to assist you to get this done. You can go to the link in the profile. It's going to take you to the website where you can schedule your own appointment, or you can go ahead and call, and a scheduling coordinator will be happy to assist you to schedule your appointment as soon as possible to get started, to confirm you qualify and then to get started. So now let us get started with the questions. Change my husband's status in USA after accepting his I-130 overseas. His fingerprinting is done. Okay, great. Congrats. How long more to get his travel and work authorization? So I've seen anywhere from 3 months to 9 months. So on average, 3 to 9 months, maybe even longer. It just depends on your case and what's going on. Now, remember that the information I'm giving you is for educational purposes and empowerment. It is not for personalized legal advice. So you should always schedule a consultation. So good afternoon. I want to find out if I can file for my dad, although he's married. or he has to be divorced. You can file for you can file for your dad, even though he's married, but his wife will not be able to come along with him. He would then have to file for his wife once he becomes a permanent resident. Or here's one other option. If you are the stepchild, you are, of course, I'm assuming you're 21 or over and you're a US citizen. If you and your dad and his wife, if that wife is not your biological parent, if that wife and your dad got married before you turned 18, then you could sponsor his wife as well, both of them. They wouldn't be included on the same application, but you could sponsor the both of them, because step parents, US citizens can sponsor their step parents as well. But you do have to show that the step parent married your parent before you turned 18. Hi there, good afternoon. I can apply for adjustment of status through my US born baby. Unfortunately not. Being the parent of a baby is not going to qualify you. Your US citizen baby has to turn 21 before they can formally submit a petition to sponsor you. My US citizen husband is filing for me a year and a half now, and I haven't heard anything from USCIS. So Tanya, I don't know why. Now the I-130 usually takes about a year for a decision, then it moves on to the National Visa Center, but it all depends on what's going on in your case. You should go ahead and check with the USCIS on that. How long does it take when you're applying for your 10-year green card? It depends on what, because remember, yes, you're applying for a 10-year green card, but how are you applying for a 10-year green card? Are you applying through a spouse? Are you applying through a parent? Are you applying through a child? Are you applying through a sibling? Are you applying through an employer? Are you applying based on investment? Are you applying based on asylum? Are you applying based on humanitarian need? So I hope you get the point there, that there are over 20 ways to get your green card, and each one of those ways have different processing times. And so it really comes down to your facts to determine whether you qualify. And then we could get into processing times, estimated processing times, based on that, the way that you're applying for the green card. I know someone who was married to an American citizen and she had given him a restraining order, but never. Now, if she was married to a US citizen and she got a restraining order, it sounds like she has a very, very good case for a VAWA to apply for the work permit and permanent residence on her own without involving the spouse. This is what I help clients with. So if there was a divorce, she has up until 2 years to apply for this. Once it gets to the 2-year mark, then it's too late and she will lose the ability to apply. So that's why I come on here and I educate viewers, because so many people, I can bet I've met individuals who they were divorced from a US citizen who mistreated them, and they didn't know that they could apply on their own based on the mistreatment, but the 2 years passed. So this is why it's important to share the live and also, join me, tell others to join me so that they can learn about this valuable information that's life-changing, frankly. All right, let's keep it going. What happens after I get my work permit for SIJS? So if you get the work permit, it means that now you have to wait for an immigrant visa number to become available so they can process you can file your adjustment of status application and then be processed for a green card. My VAWA approval last week, how long will it take for my green card? Also, will I get my interview? So the green card is going to come after the interview. And so congratulations on your VAWA approval. That's awesome. Now you just have to wait for the interview to be scheduled. That's where they're going to formally make a decision about the green card. As for length of time, it really is going to depend on processing times. It could be anywhere from 6 months now to a year to get that interview. His wife is a citizen. Hi there, Queen Josette. So nice to see you. Hi, my daughter in Ethiopia. She's I-130 approved. Now, NVC, how long does it take to come to the USA? So if your daughter, if you're a US citizen or legal permanent resident, your daughter is under 21, you could be looking at an 18 to 24-month process. And it also depends on the individual embassies and how long they're taking. COVID really bent the embassies out of shape, and so many of them are taking over a year to get the interview scheduled. Now, with the NVC, if they're 21 or over, you could be looking at, and unmarried, you could be looking at 5 to 7 years. If she's married and you're a US citizen, you're looking at 12 years. So, quick question, if you get an American citizenship and you have an American passport, can you hold a Jamaican passport? Yes, so when you're a naturalized citizen, many individuals still retain their other citizenships. No, not every country is the same, but I know it's very common to have dual citizenship, dual US citizenship and citizenship in Jamaica. But some countries, it just depends. Some countries, if they find out that you've pledged some sort of allegiance to another country, you have to give up your citizenship in that country. But the US has not explicitly stated that they require that an individual give up their other citizenship. Most of the times what they'll say though is they will not be able to protect you as a US citizen if you have citizenship in Jamaica. And say you go to Jamaica and you get arrested, and then you're trying to get the help of the US government to get out, then that may play into their decision to assist in any problems you may be having in the other country. On YouTube, hi there. I came in on C1D and planning to get married after 2 years. Will I be eligible? So if this is a crewman's visa, you need to watch out. Because this is you cannot adjust status on the crewman's visa. You will get a nasty surprise. What you do need to do is get legal advice and representation to make sure that you don't make any missteps. Always get legal advice before you start your process so that you're not making any mistakes. So the C1D, if that's a crewman's, then you could very well have a problem. And before doing anything like overstaying or deciding to overstay, make sure you get that legal advice. I am available for a consultation. You can go ahead and call the number. I'm going to type it into the comments. Or you can go to the website and schedule your own, or you can call and get the help of a scheduling coordinator. All right. What to do if my spouse overstay on his visa? What should I do? So unruly Chris 12, it's going to depend on your status. If you're a US citizen, you may be able to apply for your spouse to adjust status and become a green card holder. Now, as to what you should do, I don't give personalized legal advice here, and so I'm not telling you to go and do that until I can fully understand and give you accurate legal advice. If you're a permanent resident, then you also have to we'd also have to look at the case. But if you're a permanent resident and they've overstayed, there is an issue here in that it's going to be a little more tedious of a process, and you'd have to evaluate whether you want to go through that tedious process or whether you want to wait until you become a US citizen. So as you can see, it's going to all depend on what your situation is, what your status is, what the status of your spouse is. Can I sell my, okay, so that one is not a valid question. My parents filed for me and my daughter, but my daughter has a child. Can she get a visa for her? So my parents filed for me and my daughter, but my daughter has a child. Can she get a visa for her? So that's a complex question. A derivative can't have a derivative. So your derivative would be your daughter, and now your daughter has a child. And the visa is not necessarily, it's going to be on a case by case basis. So it's going to depend on all the facts involved, and that's where it's important to get that legal advice, because you're definitely in a complex situation. All right, great questions so far. Keep those questions coming. My wife filed for me. I'm DQ since March 2021. No interview date. I'm in Jamaica. That is, you're not alone. The wait time is very, very long right now. They're backed up. Thanks for the follow and the shares. I appreciate it. Wife filed for me. Okay, so I read that. Is there any way I can stay in my US baby legally in the US? So I've had situations where I was able to apply for deferred action for my clients because of maybe a medical issue that their child was having. However, there's, and your option is really going to come down to your facts. I don't want to say there's no way, because I don't know what your situation is. There may be options that you're not aware of, and I can't, there are too many options to describe here without really knowing what your situation is. So that's where it's important to get legal advice. So important. Does the state matter? Because I wanted to use you, but another lawyer say you had to be in the same state. Not true, Ashibu. That is far from true. As a U.S. immigration attorney, the state does not matter. As a matter of fact, oftentimes we have to file the documentation outside of the state. We, as U.S. immigration attorneys, and you'll find multiple attorneys who have practices all over the country, like me, we have to work with USCIS offices all over the country, work with immigration courts all over the country, work with embassies all over the world, and work with the National Visa Center no matter where we are. So the place does not matter, and I have my clients all over the United States. I have flown into multiple states all over the US to attend appointments with my clients in person. So that lawyer misinformed you, because that is not true. My case has been on it for 3 years now for citizenship. So that's quite long for citizenship, and you should get legal advice. I've been approved from March 30 was the day of my interview, and I still haven't received my card. So definitely get in touch with them, let them know, and see if they've sent it or if it got lost. Hopefully not. Hi there, what's your consultation fee? So it's $150 for up to an hour. It's well worth your time and money, because I do a detailed evaluation, evaluate your options, and then we get started as soon as you confirm representation. My sister and I have different dads. She is 17 years old. How can I file for her? So you should schedule a consultation, because if you have now half sisters, so half siblings do count. So half siblings do count, adopted siblings count. So you don't have to be biological, you don't have to be full siblings. You could just have one parent in common, and you would qualify as a sibling. What happens if you have two A numbers? So I wouldn't know. That's unusual to have two numbers, but it does happen, and it doesn't necessarily mean anything. But you do want to maybe disclose it, that there are two numbers, so that they're aware of that as well. If I have a green card, can I adopt a child from my country? So that's a very, very complex question, and we would need to do a consultation. Also, do you work with LGBT? Absolutely, Chrissy Doyle. I work with all same-sex, heterosexual. I work with all genders, and I don't discriminate based on sexual orientation. So definitely get in touch, schedule that consultation. I'll be glad to assist you. How long does it take to get citizenship in the US after you applied? So I'm seeing an average of about 6 months. How do those H-2B visas get to green cards? They don't go directly. You have to make sure that you qualify in some way, but it's having an H-2B alone isn't going to qualify you. Okay, my lawyer wants to not send sponsorship info for citizen married visa for husband. Is that norm? No, I don't know why your attorney wouldn't do that, and it's hard to, your attorney is advising you, but it's hard to say here why that is the norm. I don't know why you hired them. I don't know, what's going on in your case. So that's not a question I can answer. We have sent everything else on waiver, but she wants to wait. It's 3 years. So I wouldn't be able to answer that. You have to speak with your attorney. I've been DQ since March 2021. Why filed for me? I'm in Jamaica, so it's not unusual to wait this long. Unfortunately, it's quite a long wait in Jamaica. All right, so I'm going to head on over to Instagram. I'm the immigration attorney on Instagram. Thanks for sharing the live. I will be back tomorrow at around 4 p.m. to answer your U.S. immigration related questions. So go ahead and put your questions go ahead and put your questions in the comments on Instagram. I'm the immigration attorney. So join me there and we can continue to have this conversation. If you can't join me there, or if you'd like to just go ahead and schedule the consultation, go to the link in the profile. It's going to take you to the website where you'll see everything you need to schedule that. So I am going to be over on Instagram now. And if I didn't get to your question, all of these were such great questions. If I didn't get to it, go ahead and join me tomorrow, or just schedule that consultation so you can get the personalized legal advice that you need. Have a good evening, and thanks so much everyone for your time and for joining me. I'll see you tomorrow.